Good morning, everyone. For the record, it is October 8th, 2024. The time is 9:34 a.m. This is a status conference in docket number 2021.09.113 pertaining to Montana Dakota Utility Company's application for authority to offer incentives for conversion and to impose special terms for regulated natural gas distribution in the Saco-Bedoin area. My name is Laura Wachowski, and I'm a staff attorney with the Montana Public Service Commission. I've been delegated the authority by the president of the commission to preside over the status conference. The purpose of this status conference is not to discuss substantive matters relating to the application, but to determine how to proceed procedurally. As I believe everyone here is aware, Montana Dakota Utilities and the Montana Consumer Council, the two parties in the docket, filed a stipulation and settlement agreement with the commission. Thereafter, commission staff filed a staff memo and associated proposed order related to the stipulation filed by the parties. It's my understanding that the parties would like to present the stipulation they filed to the commission in some fashion and or respond to staff's memorandum and proposed order. Council, is my understanding correct?
Yes, we would like to do something. Yes, I think, yeah. And this is, sorry, this is Mike Green. I don't want to cut you off, but yes, we do need to kind of figure out how to move forward.
Okay, do the parties have any proposed way to move forward?
Well, I know that we don't want to talk about substance, but I guess from my perspective, the typical way that we've handled these stipulations is that we would move forward with a hearing, and then if the commission has concerns about any of the factual issues presented by the stipulation, I think some of which are raised in the staff memorandum, that would come out in the form of testimony presented at the hearing. We would typically, we would present testimony in support of the stipulation. MCC usually does something short to present, but then we stand for questions that the commission may have about the terms. There seems to be a legal issue as well raised in the staff memorandum. I'm not sure how to address that in a hearing. Maybe that's post hearing briefing. But I guess our perspective is, we could do some additional testimony to address some of these issues, or we could just follow the typical process and stand for hearing. We're open to either of those, and really wanted to engage in the process on where we are. We're comfortable. We still believe that that we can support the stipulation and address the issues that have been raised relative to why these 38 customers are different than all of the other Montana Dakota gas customers, but certainly open to a discussion about how to best move forward with that process.
Jason, on behalf of MCC, do you have anything to add?
Well, no, and I'm not totally, could use a kind of maybe a summary of what the concerns are with the settlement. But, if there was a commission order rejecting the settlement, then yeah, we would go, back to sort of a process and have a hearing, and that wouldn't be admissible at the hearing, and the parties could kind of revert back to their litigation positions, and the commission could be like, no, we want to decide this on the merits. They could just reject it. What happens sometimes, which I think is problematic actually, but the commission will just kind of modify or add one thing to the stipulation, and then if a party can't live with that, they kind of have the right to withdraw from the stipulation. It's only, the parties are only bound by stipulations if they're approved in their entirety. That's a provision in there. So I think that party would have procedural rights to insist on, basically going back to the litigation position and back to having a hearing. And so those things have happened, and to some degree, although I've never actually seen a case where it's reverted back to litigation completely, to be honest. I think, you know, there's motions for reconsideration and there's, but I think generally those, if there's modifications, I think it can be awkward, but I think generally the parties, what I've seen, kind of live with it. You know, some are more minor than others, but yeah, I guess, you know, I think Mike and I are here to still kind of urge the commission to approve the settlement. And if there's concerns or specific questions, you know, we may or may not be able to explain kind of how each party got to where it did, but certainly happy to try to clarify or discuss. But you know, my position is like, yeah, what process do we need to persuade staff and the commission to approve the settlement? If any, you know. So that's kind of where I'm at.
Okay, thanks, Jason. So if I'm hearing, Mike, what you said, you're perhaps suggesting maybe there be a hearing on this stipulation, and to the extent there are legal issues, those could be addressed in potentially post-briefing if they're not addressed at the hearing somehow.
I mean, I think even pre-hearing briefing, I think the issue about whether or not the special terms and the liability, the modification to the terms of service, I think there's some issues raised in the memorandum. I think those could be addressed prior to the hearing even. And then to the extent that things come up after the hearing, you know, we could probably even do that, but I think those are,
Well, I guess one question I have is why can't we talk substance here and now? You know, this is on being recorded and live streamed and everyone's present. Like if, you know, if staff wants just to explain substantive things here, you know, I don't know if that's exactly where Mike's at, but I suspect, you know, there's certainly hearings on settlements a lot. Especially in big cases, you know, and the commissioners, there's often a very thorough, you know, it's often like a very long, it's almost not that different from how the hearing would have been if we hadn't settled. But I presume if we have a hearing on, you know, the way if we have a hearing on a settlement will happen is, you know, Mike and I will show up and make statements in support of the settlement, and we won't cross-examine each other's witnesses. And so I don't know if that would be satisfactory or that's what is wanted, as opposed to just sort of explaining, if there's something you just think we got way off on one side or the other, or you don't think can be done, or I guess is illegal or something. But I guess, yeah. And I guess, you know, I apologize for not maybe being totally clear on what the concerns are.
and I'll just say, I'm happy to talk substance today as well. I mean, obviously we're not going to resolve that, but I think maybe having that multilateral discussion of the substance would be helpful, and then maybe that helps inform how we move forward. But and
yeah, and you know, in this case, you know, the way the rebate costs, for example, are recovered and over what time period and through what mechanism, you know, that wasn't, you know, that's not the simplest thing, but sort of the rebate itself and the concept of this service, you know, that there probably does need to be a transition, you know, and that this is kind of a unique service that affects certain customers. And so, yeah, I guess I'm just, you know, is it the details or is it the concept of like these people are being abandoned kind of thing?
So Mike and Jason, we're not going to discuss substantive matters here today. The commission isn't here. The staff doesn't make decisions. Obviously, we only make the recommendation, which, as you know, has been filed and made to the commission. It hasn't been presented to the commission, as you know. I think I would agree with you, Mike, that there are some legal issues here that probably could be addressed pre-hearing. I think there is some factual information that Jason, you and Mike, your clients may wish to address some of the issues in a factual manner that were raised by the staff's memorandum. If you wish to do that, how you would like to do that, a hearing is fine. We can set a hearing for that. But I agree that there are some legal issues that, however, the parties, if you would like to do some post-hearing briefing on those legal issues that you identify, that's fine. If you'd like to present live testimony about some of the factual issues, that's fine too. You said you're comfortable supporting what you have. I think we're open to that, but this isn't the time to discuss substantive issues. I think the commission needs to be involved in that discussion. They weren't invited to the status conference. It was always envisioned as just being sort of a procedural conference. So I would prefer that we just talk about procedurally how you all would like to go forward from here, and then give you an opportunity to discuss issues substantively in front of the commission.
I think I think that's fine. I think we're open to setting a hearing, and maybe there is a threshold legal issue in here that I think needs to be resolved, relative to whether or not the commission can agree to special terms and conditions. And it seems the staff memo seems to imply that you cannot have customers kind of accept the risks of the risks associated with the raw gas. And I guess that my concern is I'm not going to go to a hearing. I don't want to bring somebody in from Bismarck if there's no way we can do this. Because if that's the case, if we cannot have clients, or if we cannot have customers do that, then we're going to be back to the original, docket that I filed in whenever that was, 2018, which is an abandonment docket, because I don't think it is appropriate to ask all of the Montana Dakota customers to take on the cost and risk of these 38 customers who are absolutely unique in the system. So that, I guess I'm open to, how do we address that threshold legal issue? And then once we get over that, or don't get over that, that dictates whether or not the rest of the stipulation can be presented to the commission or not, I guess, from my perspective. I don't know if you disagree with that, Jason. But, I mean, that's the whole theory on which we dismissed the prior case and filed this case, was that the commission could allow these customers to continue to take service and get the benefits of their system while shifting the risk from the rest of the customers to these customers. So that's a threshold legal issue that we need to figure out.
Yeah. And I mean, it's a valid issue. And like Mike said, when this first came up in 2018, that was kind of my primary focus, was MDUs trying to get out of this. And even if the gas is sufficient to provide service, that they would just be appreciate being relieved of this burden kind of thing, and get, not have to serve these people. And, there are freeze ups and they have to send folks out, and, there's a cost to all that, that's borne by all MDU customers, I think, or possibly, there's some risk of that, even of course, that, to keep this going. But over the years, as we've gone through like kind of heating season after heating season and seeing some of the pressure issues, my goal has been more like, for folks who, I guess it's optionality, where, some of these folks may be sick and tired of, and I'm speculating here, but, sick and tired of stuff freezing up and happy to have a rebate to switch fuels and would be eager to do so. Other people may not want to do that and they don't mind, the service has been fine, or they're willing to deal with whatever. And as long as it's available, even still, the rebate expires. But yeah, like Mike said, this is different than an abandonment, I think. But it does have a similar feel, in the sense of the reliability of service, the obligation to service sort of shifting. It's not going away, but it is changing in recognition of the, like it not being possible to provide service. So is it MDU's job, for example, to like bring in propane and service it? And And I mean, it's an interesting question, I think, for classic utilities, but this situation is actually a little different because the relationship between these customers and the utility began and existed over time, quite a bit of time as a contractual relationship. And I understand that it may technically have met the definition of providing the service and made the entity doing so a public utility. I think we've seen that in a lot of spaces actually pop up. But what I'm saying is, these customers agreed to allow an easement across their land, and in exchange in the contract where they gave away that land right, they got the right to, this gas, this untreated raw gas, which has been very, affordable. It's like been a good deal, and it's gone on for a long time. I think we're past the term of the original contract. And at some point along the way, it started to be looked at, and I probably correctly so, as sort of a something that should be tariffed, and that there's sort of the utility has certain obligations that may be above and beyond the contract, and so like if the customer doesn't pay their bill, they're not just violating the contract, they're kind of subject to like to be treated under the commission's jurisdiction basically and tariffed. But I do think just is the voluntary kind of bilateral nature of how, this makes it a little different on top of the fact that, it's just not possible to provide service. And I don't put a lot of weight on the fact that MDU voluntarily released its control of the actual gas gathering fields and pipes, and now they're subject to, like, if that company suddenly goes bankrupt, they can't, they'll have to stop. I kind of hold MDU accountable for that, but I don't hold MDU accountable for the fact that everyone always knew that the gas fields would deplete over time and someday go, run dry. And there's literally not enough pressure to even, certainly not to provide these people reliable service. So when they signed up for this, I think the depletion issue of the gas fields, I don't know if that's an abandonment, but it definitely feels like a pretty unique situation here. And we see it also exists in Havre Pipeline Company also, and that's come up too, where whether that's subject to the commission's oversight and should be tariffed, et cetera. But it is, yeah, it is. I don't know if there's just that MDU should continue to serve these people, or over the years, I've come to recognize, I think MDU has, and I'd like them to continue to, for those who want this service as it kind of depletes and gets worse over time, I would like to see MDU make that, like, serve those people indefinitely and not abandon them. But I do think for the customer's sake, it's not fair to them to just sort of wait till it becomes a crisis. I think this rebate idea is a good one here in this case. And so we're letting we're kind of loosening the normal public utility burden on MDU, I would agree, but we're also trying to, it's, and again, keep in mind, to the extent this is an expensive thing to maintain that other MDU customers may be paying for, like service trucks, outage guys, they have to send people out there in the middle of winter. I'm a little sensitive to, like, the sort of cost causer, who pays, who's causing the cost situation. And, if these people really want MDU to have to serve them forever, then that's maybe should be based on whatever they're doing. Like if they have to bring in propane. But I've come to recognize that there's, the pressures and the gas is depleting, and it's more a question of when. And I think it's reasonable for MDU to kind of come in early and be like, this is coming. We want to address this and enable these people to convert. And it feels like they've acted in good faith after all these years. We've been through a number of seasons, and they continue to serve these people. And so I think it's in everyone's interest to kind of move on from this, like, just thinking of it through the lens of, like, you can't give these people special treatment. I mean, the commission can set tariffs that it wants, I think, and this is a very unique situation. There's a logical reason why the description of the quality of service and reliability would be different in this tariff and then like Haver Pipeline than it is for a Northwestern Gas customer and, you know, Bozeman, from sort of a safety and risk and reliability standpoint. I wouldn't expect those tariffs to be the same. So anyway, I'm sorry to kind of ramble on there, but.
Oh, that's fine, Jason. So, let me just say this from speaking just from staff's perspective. I don't speak for the commission. And as I mentioned, our staff memo hasn't been presented to the commission. So it's just what it is on the face of it. So the concern, excuse me.
Well, and so one more thing I actually wanted to reiterate what Mike said is we're happy to have a hearing. I mean, it's like, yeah, tell us whatever process staff wants and,
So I think as far as the legal issue goes, the concern is indicated in the staff memo, and my apologies if this wasn't clear, is not that there isn't a recognition of a special situation, because I think everyone here recognizes there is a special situation out there. It's not the same, you know, to the extent that it's somewhat similar to the Haver situation. It's somewhat similar, but not identical to that. But the tariff language that basically absolves MDU of any and all liability is problematic, because the concern is that they're not recognizing that they basically, under the law, at least as staff sees it, you know, they need to be held accountable for their own wrongdoings. And so to the extent that that tariff language could be modified to parallel the other sections of the existing tariff where MDU does reserve, you know, basically owns up to its liability for its own wrongdoings, I think that is something that could be addressed in modification of the stipulation, or if MDU and MCC disagree with staff's position on that, then that could be addressed in a legal argument. So I see that as a
yeah, and
legal
that's fair. That's,
As a-
you know, yeah, and we're happy to.
Yes, as something that because it is different than the rest of the language. It's pointed out in the staff memo, some of the other language that is in the existing tariffs already that make it clear that while it's giving up, you know, some liability, it's still retaining liability basically for its own wrongdoings. And that is what seems to be missing in the proposed tariff language here. So that is a legal thing.
Yeah, I mean, and I think I agree with you, but for example, if in a normal situation, if the power or the gas went out in the dead of winter for a week and the pipes broke and all your property was lost and your house was totaled, you would have like the liability might be with the utility there. But in this case, it's almost like these, you know, there does need to be some transition perhaps of like, I don't know what you mean by like MDU being liable for its own. It's just if there's a different standard of service, they may be less liable than under normal conditions. Like if there's a freeze up and they can't get out there for 3 days, I'm not sure they should be liable for that, you know.
Well, and I'll just jump in real quick. I mean, I think that was, as I look at the language, certainly were not trying to escape liability for the company's negligence. What we were trying to say is the company's terms of service for these customers are different. Therefore, the negligence standard is different. And we really did try. I mean, this is the part where there's a disconnect in the memo. We were trying to limit it to things related to it's quality, quantity, pressure, or availability of gas.
Right.
I mean, it's not, you know, if MDU sends a guy out and he relights the pilot without doing it, we're not trying to say that, right? That's not, it's not that, it's just that, it's the issues that all come from the rural nature of this. And so that's the part where
the service itself. Yeah.
I mean, that's the part where I don't know how we can accomplish our goals. Here's my struggle, Laura. I don't know how we accomplish our goals and refine the language or have different language without having a discussion with you all I'm not sure what would satisfy staff as far as you being comfortable with recommending it. I don't like to go to the commission and say, I disagree with your staff. So that's, I mean, I'm happy to do that and we can have an oral argument in front of it. I'm not sure, I mean, it puts you guys in an awkward position then of advocating a position on behalf of staff as opposed to a party in the case, which I always think is kind of odd. But so I guess procedurally, I'm at a little bit of a loss on how to address that issue other than engaging in a discussion. And from there, I think the factual issues, most of which Jason has outlined, you know, I think those are easy for us to establish. There are some questions in here that we can easily answer about why we propose things in the stipulation. But I just, from my perspective, it's two separate issues, and the threshold legal issue is the big.
Yeah, and it's a valid issue and a valid question. I mean, it's a good question. And forgive me if I'm veering into substance here, but like, correct me if I'm wrong, Mike, but hasn't it always been the case under these contracts that the company has like what you maintain stops at like the tap? And so all the stuff, it's often you go out and you find what's frozen up is like on the customer's equipment. And I just thought, and then, you know, that normally like the company can, you know, they have the right to come read your meter, replace the meter. Their kind of responsibility for the service goes right up to the house. And I guess I thought, and you know, I thought it was the case here that you agreed to provide the tap, and then the customer's basically responsible for like all the kind of from there, from getting the gas to their house and then having proper like regulators and insulation, and you guys don't have any window into that. And I'm not saying whether that's right or wrong. I'm just saying that's something that makes this situation a little different than your normal kind of what the company might be liable for or responsible for maintaining, you know. But anyway,
I think two characteristics that we're worried about are the difference in worker safety. Montana Dakota's customers are primarily located within municipalities. And so I mean, our people live there and they're serving small communities. These customers are all remote. They're not, I mean, you're driving through snow drifts and unplowed roads and all that. So there's a difference in personnel safety for our folks. And then the other is, you know, if a main freezes up in Glasgow, for example, people are going to know that. So even if somebody happens to be gone, right, the neighbor's going to freeze up and they're going to know their gas is out. And so MDU can respond to that and they'll be able to deal with that, and they'll be able to, you know, before they restore service to all the homes on there, right, they'll be able to go through and make sure there's no pilots and all of those. There's no gas that's built up in a basement and all of those things. So that's a different issue. Whereas these can be one little lake cabin freezes up, right? And you might not even know that froze up until the guy shows up in the spring to open the door and blows up the cabin because it's filled with gas.
Well, and another, you know, oh, sorry, Mike.
Go ahead.
Well, on that point, I mean, it's almost more like the freeze up is far less likely on the MDU gas system because it's treated gas. I mean, this is raw gas. So there's water in it. There's all this other stuff that it's, you know, this isn't, you know, it's a different product basically than what you get on the MDU or Northwestern gas system. So there's just issues associated with that that I think are relevant to sort of liability and expectations. And all of this was, again, set up through a voluntary bilateral contract, which, again, I'm not saying that was right or wrong necessarily, but that's just what framed the terms of service initially. And now they're being framed through tariffing, which is good, I think, but it's not good to try to set this tariff as if this is, I mean, I think tariffs should be written to like specific situations and, you know, yeah, it's a difficult situation. So, but
So I guess how do we, and if today is not the day to resolve that, I understand that. That's the issue is, do we want to just present argument to the commission? Do we want to sit down and, I mean, do we want to schedule a time to sit down with staff to address your concerns about this? and see if there's a way we can overcome that. We can schedule a hearing and I mean, I think we can run those as parallel tracks. I'm not saying let's hold off on a hearing. Let's get that scheduled because we've got to get that set. But I mean, I would like to engage and then, I mean, I think MDU is open and we're going to have to change the terms of the stipulation because the dates have now passed. So we've missed the dates anyway. So we're going to have to fix the stipulation. MDU is committed to trying to resolve if there are issues here where we can meet Jason's needs, you know, his desire to have optionality. I like that word that he used. We're open to that conversation. But if we can't come to that, then I don't think there's any reason to present the stipulation because we have a very different problem that requires a difference.
Yeah, and my thinking is a lot of these customers will take advantage of the rebate. And they have, I think, a pretty decent window of time to do so. And, you know, MDU has to notify them and stuff. So they have this opportunity, they have time. And I could see them taking the $10,000 and, you know, switching fuels basically and being kind of not really disgruntled about that because, again, they're getting raw gas, low pressures. It's, and so, but then there may be other customers that, don't want they just want this as long as it's available and you know that's where I appreciate that MDU is open to that because I think if they can do that that's it's good for these folks to have the choice, but I do accept that it might be next year, it might be 10 years, it might be 15 years where there's just not going to be gas. So, and at that point I think it's a tricky question about kind of who's entitled to what and all that. So it's an unusual situation.
So Jason, I like Mike's suggestion that maybe the parties and staff could sit down and talk maybe about the tariff language and staff's concerns about that, and then setting a hearing so that you on behalf of MCC and Mike on behalf of MDU can present the other matters to the commission and address the issues raised by the staff memo related to those things and whatever else the parties would like to present to the commission.
So yeah, I would push back on that a little bit because I guess I just wonder, why doesn't staff present the staff concerns to the commission? Like, why should we have to respond to them, to the commissioners before? Like, it would be more straightforward in my mind for you to have the work session, present the memo, convince the commissioners, and then they reject or modify the stipulation, and then we go from there. But I agree with Mike that the role of staff's a little awkward here because in this case, for example, with the liability, it sounds like you want to tighten it up for MDU. I'm sure I won't reject it or object to that. So if you can just get Mike to agree to the different language in terms of, not letting, like, narrowing, not, addressing that provision, it's not a modification that I would have a problem with, I don't think. But it just feels weird to present to the commissioners in response to staff. Or maybe there should be staff should present first and then we are there to respond. Maybe that would make sense. But just to show up cold and be responding to a staff memo is a little, again, it's awkward because these things cut both ways. So if it's something that benefits me, maybe I would say it's weird for me to show up and be like, I actually agree with staff. I wish I could have gotten this out of Mike. I'm not going to do that because that's not how I see settlements. I'm not going to kind of undercut our settlement, I guess is what I'm saying. But then there might be things that staff's proposing that I don't agree with. And I guess it would all just be in the context of supporting the settlement. So I don't know if that's what you're going for, but I think you should present the memo to the commission, and then if whatever you want from us, is fine. I guess I'm not comfortable with sort of the adversarial role between parties and staff. I don't think it makes sense procedurally or substantively.
Well, and Jason, so this goes back, my concern about the memo was that it identified these issues, recommended denial of the stipulation without us having an opportunity to address the commission, and that's where, that's where my objection to the whole process started. If we have an opportunity to do an oral argument, I guess, in front of the commission, and the staff can present their argument and we can present ours, and then the commission can rule, I suppose we can do that. I'm enough of a pragmatist to think that I would rather, if there are issues that we can resolve to address staff's concerns on the legal issue, I guess I'd kind of, maybe the commission will disagree.
I guess what makes it a problem for me is that settlement discussions are confidential, and you do see sometimes, like, there'll be questions at a settlement hearing, like kind of they want to know exactly what was traded, how parties valued everything. And I find it very awkward to be like trying to score, get a better outcome than I got through the settlement at this point, or getting a worse outcome and oppose, like, at this point, we've agreed on this, and so it just would almost be cleaner, just go back to litigation positions, let us have a cordial hearing, and you guys can pick and choose what you like and what you don't, and customize the outcome however you want. But it makes me uncomfortable when I feel like it's, how did you get here? And just, they want to know, settlement discussions. And in this case, it's not, this case is pretty straightforward, but like in a rate case, for example, that, it's not appropriate, I don't think, when, opposing counsel does it, and I don't feel comfortable doing it, where you take the opportunity to like score additional points. It's like, you should just defend the settlement. And there's a bit of a black box nature to this, where you don't know exactly who traded what usually. And so if you need to know that, then let's just litigate the case and reject the settlement, but to modify it or come in and add things, or I don't know, it just it undercuts the settlement process, I think. And I would just kind of had a different presentation at a settlement hearing, than I would in just a meeting with staff, which is, I'm all for that. Let's just sit down and talk about it and figure it out. But you might, sometimes what you might want from us is more of like, to just go back to the basics and like let us just present our positions, and then you can do whatever you want. So.
All right, so maybe I'm hearing a couple different things. Jason, you would be fine with us just presenting our recommendation to the commission. They can vote on it as they feel appropriate. Should they agree to reject the stipulation, then of course we would just be back where we were before the stipulation was filed, and we would proceed to a hearing, and each side would.
Yeah, and I do not, I'm not speaking for Mike here at all, because he may want an opportunity to respond to the staff memo, but just speaking for myself, I'd be comfortable with that. And I guess I thought the purpose of this was to kind of hone in on exactly, like, Mike, we're wondering this about you, and Jason, we have these questions for you, and but I don't know, I see staff memos all the time that contain stuff that it's like, maybe I don't agree with, but the process normally is like the staff, presents to the commission. They often make a recommendation. It's often pretty specific, and there's not an opportunity to like respond to that before the commission decides what to do, and the commission has the whole record in front of it. And then Mike and I could ask for reconsideration, which is usually how we would resolve this. But in theory, I've never seen it happen, but either of us could withdraw from the stipulation and have the right. I think that party would have the right to demand a hearing and whatever they would have had if they not settled. And the settlement should not be admissible in that down the road. So there's an easy way if the commission wants to revert back to like sorting through the merits and the weeds on all this, but it's just awkward for me personally, and I think it's awkward for others to really be grilled about a settlement when it's, you know, you're just going to get positive statements from us. I think at this point, that's what I usually see is like witnesses will get pinned down. Like, you said this in your testimony and then you agreed to this. And the answer is always kind of like, well, in the context of settlement and the whole package, it was within the range of reasonableness ultimately for me. And, you know, that you never quite get the, like, you know, to see the math or the parties. Even, you know, even Mike and I in a complex case, I don't know how he valued everything or what he thinks he gave up exactly. And he doesn't know for me. So it's kind of black box to the settling parties often, you know, not so much in this case, but so it's just an awkward process at this point. And I just, yeah, I'm not sure. It feels weird, you know, and you said the commissioners aren't here, so we can't talk about it, but it's almost like, shouldn't that enable us to talk about it? You know, it wouldn't be ex parte anyway, since we're all here and had notice of this, but, you know, why are we having a separate conversation with staff? And if we're going to have a hearing with the commission, it's kind of like, who are we talking to, you know? So to me, you guys are kind of all one and the same. And yeah, just, I guess, tell us what you want, you know, but like, if you think we need to redo the settlement and you cannot accept it as it is, then, you know, let's figure that out. But it's hard to get to the merits in this context, I think, where we've resolved it, because we're not cross-examining each other. You know, it's just a different situation. So.
So I think,
Yeah, and as to the legal thing too, again, neither of us can sue you, right? So if you do something illegal, neither Mike and I could sue you over because we agreed to this. We have no standing to challenge. You approve our stipulation and maybe there's a provision. And so I guess if you're worried that one of these customers might someday have grounds to challenge the legality of something in the tariff, but I just have trouble seeing how that plays out as an actual legal concern. So,
well, just, I think
and you know, the commission defines the terms of service, but I don't think negligence law just goes away. So if MDU does something truly negligent, I think they have a tort claim, and I don't think this tariff changes that. So this is just it's like a contract with the utility but now it's being written by the commission. Anyway, so yeah, so I guess I'm just thinking of this more practically and how to kind of do maybe what's best for everyone over time, but and also just how many resources to kind of dedicate to this, where I really do think we've actually found a pretty good resolution to this. So you know, yeah, but again, you guys should tell us what you want. And if you want to have us come respond to the memo, you know, I'll do so. But I'll be there kind of in support of the settlement, not to litigate my position that we took in the case, you know.
like, do you,
Yeah, I'm concerned about having the commission deny the stipulation outright, because I think at that point you do go back to the litigation position. And this has now gone on long enough. Maybe it's a different issue than a lot of cases, because we are now in a position where I don't think if we were going to file this case today, this is not how the case is posture. So we're still willing to stand by our settlement, but if the commission rejects this settlement, I don't know we're in a position to agree to these terms if we have to refile. I mean, I think this is you know, I just don't know that that's the case. So I think we've invested a lot in this, and so I'd rather try to defend the settlement to the commission.
Right. Yeah, same here. That happens all the time, and that's fine. It's just sort of the third position that now has come into it that we're have to respond to, and then the commission might hear all that and then have questions of staff, and it's just an awkward maybe the first question the commissioners will ask is, we'd like to hear your response to the staff memo, and then they're gonna have their own questions. And that's great. I mean, I just feel like it's sort of an abstract thing we're responding to until we, kind of, yeah, I'm at the point of, I'm happy to try to, whatever you want or I can do to persuade the commission to approve the settlement. I'm all for that, but,
So this is what I'd propose, because I'm hearing a bit of a disconnect, Jason, about how you might think you'd like to proceed forward, and Mike, how you'd like to proceed forward. Can the two parties get together and in the next couple of weeks and see if they can reach some agreement as to how they like to proceed? And if they're
Well,
not able to do that, I guess staff can just move forward and present its recommendation to the commission, and we can go from there.
I don't think we disagree, Mike. So,
I don't either. I think the issue is, I don't think we disagree. I think we want to have the stipulation presented, and to the commission. I think I would like an opportunity to respond to the staff memo to the commission. That's my concern. So I'd like to,
yeah,
there are some factual holes, which I think, that were identified, which can easily be filled with testimony. There's legal argument that I think that can be made to address the legal issues in the memo. So maybe that's the way we do it.
and I have no objection to that, and I support Mike having that opportunity. So and if there is that, I may also weigh in, I may not, but if staff didn't give me that opportunity, yeah, that's the only difference. I'm willing to use reconsideration and kind of a more, typical process, or just having a normal hearing on the settlement if that's what's wanted. And there's a certain structure to that, but Mike wants to respond to the memo, and I support that, and and if there's, again, given the process, perhaps I will as well, or we may file a joint response even, so I think we're on the same page. Mike's just a better sport than me, so.
So is the same page, you just simply want the commission to set a hearing that you can present the stipulation at, and whatever else, legal arguments or et cetera?
If that's what you want, Mike, I'm fine with that.
I think that's fine if there are. I mean, a hearing is not an appropriate place to present legal arguments. We have to figure out a different way.
Yeah, Laura, do you mind if I jump in here?
Go ahead, Lucas.
Yeah, so, hi, Jason. I don't know if you can see me on the video, but Lucas Hamilton.
Hi, Lucas.
Yeah. Would the parties be open to submitting a brief to the extent there are factual holes that need to be filled? You could include a supporting affidavit or supporting exhibitive testimony.
Well, I'll defer to Mike. Adding new issues or adding evidence to the record, new facts, defending the stipulated outcome and including that it's legal, that's valid, but then sort of introducing all this new evidence that may benefit one party or the other. Again, I'm open to it's just an awkward procedural thing where the parties have agreed. And it's kind of like, do we get to cross-examine the people introducing this new evidence into the case?
To be clear, Jason, what I'm talking about is just whatever supports the settlement agreement, right? Not trying to bolster any party's original position, right? To the extent that there's a hole that can be explained in the settlement agreement, that's what would be provided in this brief.
Okay, yeah, based on the staff memo. Yep. Sure.
Yeah, yes, is the short answer.
Yeah, I guess this is unusual. There's aspects that I think are awkward, and I'm probably not explaining it well. This isn't normally how this goes, but yeah, sure. I mean, I'm happy to do whatever it takes to at this point convince the commission that it should approve the settlement. So we'll respond in a brief, we'll show up for a hearing, but if you're like, MCC, why did you, I mean, there's just examples of questions that's kind of like, that was obviously a concession. You could read our position and then see that we moved on that, or that MDU made concessions. And then the answer again is always like, we compromised. We met somewhere in the middle. We balanced. There were multiple issues, including the recovery of these rebate costs, the timeline, how long this would go on, when the new terms would go into effect, how long the rebate would be available, if and when it would expire. All these were like things that we both compromised on. So, and I don't know, I guess I just think it speaks for itself, and it's awkward to like try to rehabilitate something that we support, or yeah, like harmonize it all with yeah, again, I think it's
I think we understand where you're coming from, Jason.
Okay.
And so it may not be necessary to provide any supporting new testimony to justify the settlement agreement, if that's.
Well, I actually like that approach, and I think there's a certain efficiency to it. My only concern is we do that, we address staff concerns. That doesn't necessarily address commissioner concerns, right?
Right. Yep.
Commission also hasn't had an opportunity. So I guess my thought is what we've typically done is in cases where there are questions about a stipulation, we have a hearing on the stipulation. And so I feel like I would love to just draft testimony and submit legal briefs to you all and have that answer all of the questions. I do not pretend to anticipate, though, this is Commissioner Pinocchi's district. He very well may want to ask questions at a hearing to justify why he could ultimately support this and why this would benefit his constituents. And I'm a little concerned about my ability to anticipate what those questions might be in the supporting affidavit. So what I don't want to have is we go through that process, you all go through a big review, and then Commissioner Pinocchi still has concerns, and so we end up here. I think from an efficiency perspective, I'd probably be inclined to say, let's set a hearing and we can address legal issues in briefs if we need to.
Fair enough. My question stems from the point you made earlier, though, Mike, where a hearing doesn't make sense if you can't get past the core legal issue. So addressing the legal issue in the first place was the intention of the brief. The hearing may still be necessary. Yeah.
And that's fair. It doesn't happen much anymore, but when I was at the commission, and maybe this has changed, but I don't know why we couldn't just meet in the commission conference room, as long as Mike's there, I'm there, you guys are there, and have a very frank discussion with staff where there's no concern, because you guys are advisory to the commission, you're not advocates or whatever. It would certainly be a problem if it was like there was a commissioner there, an ex parte. But if all commissioners were there and it was noticed and all parties were present, that's not a problem either, as long as those need to be public meetings, because it's the commission meeting. So that needs to be open to the public. But with staff, I've just been in a lot of meetings over the years where it was like just meetings to clarify, give us a crack at it with you, and not create all this record when maybe we could persuade you, or maybe not, but you could at least go to the commission and be like, yeah, we have these concerns and you've heard from us, but I don't know. So I just think we could do this much more informally. And like Mike said, if the commission has questions or concerns, then yeah, let's have a hearing. Let's do some briefs, whatever that takes. But if you guys have concerns, let's just sit down and hash it out. And I'm not saying we're going to resolve it, but that would be plenty of opportunity for me kind of with this to respond to the staff memo or try to figure out if there's really a stipulation should be denied conclusion here.
And I'm certainly open to that if the staff is, but I mean,
and again, maybe I'm wrong and maybe that's changed, but I always thought that was one of the advantages of having an advisory staff, that you could, it's, to me, it's an advantage. So
staff is fine sitting down with Jason, with you and with Mike, in the near future to further, explain or answer any questions about the memo that staff has filed with the commission related to the stipulation. And certainly we can, at the same time, set a hearing date. So the parties have an opportunity to present the stipulation to the commission and let the commission ask questions. Would those two things work for everyone?
Works for me.
Jason?
Sure, if that's what the commissioners want. Yep.
All right, let's do that. Let me check some of the dates we have here and I'll email you both with some proposed dates and let's try to get this thing moving along.
That sounds great.
Okay, so yeah, sounds good. Thank you.
Okay. Thanks, everybody. I guess we can wrap it up today. Thanks.